risk-free rate and risk premium in legal valuations. When applying risk assessment principles to legal valuations, understanding the risk-free rate and risk premium is essential. These components are widely used in valuation models, particularly in the capital asset pricing model, CAPM, to determine the cost of equity and assess the value of businesses in various legal contexts. 1. Key concepts. Risk-free rate. The risk-free rate represents the theoretical return on an investment with zero risk, commonly based on government securities, e.g., U.S. Treasury bonds, as these are considered virtually risk-free due to government backing. In legal valuations, the risk-free rate serves as the foundation for assessing an investment's minimum return. Risk premium. The risk premium reflects the additional return investors require to compensate for taking on risk. It is often broken into two components. Market risk premium, MRP, the extra return over the risk-free rate that the overall market is expected to provide. Company-specific risk premium, additional risk factors tied to the company's financial health, industry conditions, or legal issues. 2. Application in legal valuations. Business valuation. Risk-free rate, a baseline for discounting future cash flows. Risk premium, adjust for uncertainties in cash flows, market instability, or company-specific risks. For example, litigation affecting a company's reputation or operations increases the company-specific risk premium. Regulatory changes may increase the perceived market risk premium. Shareholder disputes. Risk-free rate and risk premium are critical in determining the fair market value of shares during disputes. A higher risk premium may lower the valuation of shares, affecting settlements in cases of minority oppression or buyouts. Damages calculations. Used to discount future losses to present value. The risk-free rate ensures the calculation isn't inflated, while the risk premium accounts for uncertainty in recovering damages. Mergers and acquisitions, M&A. Buyers and sellers rely on risk-free rates and risk premiums to negotiate fair purchase prices. Lawyers must ensure these inputs are reasonable and reflect current economic conditions. 3. Legal relevance. Key considerations for lawyers. Challenging assumptions. Lawyers must scrutinize the choice of risk-free rates and risk premiums in valuations, particularly in disputes where these assumptions may be biased. Regulatory context. Certain industries, e.g., utilities, banking, may have prescribed or benchmarked risk-free rates or risk premiums. Lawyers must ensure compliance. Judicial scrutiny. Courts often require experts to explain their assumptions for risk-free rates and risk premiums in valuation cases. Lawyers must prepare to defend or challenge these assumptions. 4. Practical example. Scenario. In a shareholder dispute, the valuation of a minority shareholder's shares is contested. Risk-free rate. The financial expert uses the yield on a 10-year Treasury bond as the risk-free rate. Risk premium. A market risk premium of 6% is applied, along with a company-specific premium of 3% due to ongoing litigation risk. Role of the lawyer. The lawyer for the minority shareholder challenges the 3% company-specific premium, arguing it overstates the impact of litigation on the company's future cash flows. By understanding the risk-free rate and risk premium, lawyers can effectively analyze and challenge valuation assumptions. This ensures fair outcomes in disputes, damages calculations, and M&A negotiations, where risk assessment plays a pivotal role.